mental disabilities and the criminal justice system. I'm Elizabeth Kelley. I'm a criminal defense lawyer, and I specialize in representing people with mental disabilities. On this podcast, we provide information and hope to people with mental disabilities caught up in the criminal justice system, as well as to their families. This episode is part of a series where we will talk with various authors who wrote chapters in the upcoming second edition of my book, Representing People with Mental Disabilities, a Practical Guide for Criminal Defense Lawyers, published by the American Bar Association. In this episode, we are joined by Dr. Eric Drogin. I commend Dr. Drogin's biography to you, which are in the show notes. In short, he holds a JD as well as a PhD. He holds numerous faculty appointments, including one at the Harvard Medical School, and he is a life fellow of the American Bar Association's foundation. Dr. Drogin, what is competency and why is it important?
Competency is, in almost every jurisdiction, a combination of the ability to understand what's going on and what could happen in the future in one's criminal case, and also the ability to work with counsel in order to make things come out the right way.
So to clarify, the accused has to have both the knowledge of what's going on and the ability to assist counsel, correct?
Yes, with minor variations from jurisdiction to jurisdiction.
Now, the question that attorneys ask me the most frequently is the standard for competency to stand trial the same as the standard for competency to plead guilty?
It's almost a trick question, depending on how far back we go in the history of the case law that addresses these two issues. It is generally understood that competency to stand trial after Godinez versus Moran encompasses all of the different competency functions that could be wrapped into that notion.
So if I can put you on the spot, is it a straight yes or a straight no answer?
It feels like I'm on the job today. And the answer is it's neither a straight yes nor a straight no. If we're talking about competency to represent oneself, more recent case law has carved that out, walking back Godinez versus Moran just a bit.
And is the legal definition of competency the same as the medical definition of competency?
I would say no, if only for the fact that there is no medical definition of competency.
Ah, that clarifies things. So how is a forensic expert like you supposed to fit your observations into a legal definition?
By knowing that legal definition from the start and by bearing it in mind at every stage of the conduct of the competency evaluation.
Now, if a criminal defense lawyer is representing an individual who perhaps the family has already said was diagnosed at a young age, is that in itself incompetent to proceed?
Well, here's your straight answer of the day. The answer would be no. It is
okay.
Not.
So given that situation, are there some red flags a criminal defense lawyer should be alert for?
Yes, there are.
Can you tell us some of those red flags?
Certainly. Difficulty describing to counsel what the client wants. Difficulty remembering what it is that counsel has recently told the client. Bizarre unrealistic expectations for the outcome of the case, and bizarre, unrealistic explanations from the client's view of their own behavior in the past and also during the pendency of these legal proceedings.
Given all that, are there some conditions, some diagnoses that are more likely than others to render a client not competent to proceed?
Yes, there are, and chief among these would be an intellectual developmental disability, formerly termed mental retardation, and various versions of schizophrenia, including that and other psychotic diagnoses.
And I have sometimes had clients who are so seriously depressed. That is to say, they have a diagnosable condition of depression that they just don't seem to be in any position to assist me. Is that an accurate assessment on my part?
It would depend on the client, but it is certainly an accurate concern on your part. Just because someone doesn't have one of the usual suspects among the competency depriving diagnoses, that doesn't mean that the individual is competent. In depression, for example, there can be a catatonic form of the disease that renders someone virtually incapable of moving or speaking. That is not the sort of person who is ready to participate rationally in their own defense.
Now, I want to talk for a minute about how a criminal defense lawyer finds a forensic expert. First of all, let's focus in on a public defender or a court-appointed lawyer. Where might they go?
If this is the first time they're looking, they would do well to go to their colleagues, starting locally. Their colleagues may be able to explain to counsel that a certain expert is unpopular with the local judges, or well-respected and in demand in the opinion of the local judges. If we're talking about the public sector, issues of cost can be important as well. Word of mouth is helpful, and I think by now, virtually every jurisdiction, there are members-only listservs where public defenders and other public sector lawyers can ask one another about the attributes of various potential experts, and again, for the newbies, to identify them in the first place.
If counsel has the ability to retain an expert, other than the fact that theoretically that attorney can pick whomever he or she likes, are there some particular advantages to that in terms of, say, disclosure?
If you're talking about counsel's ability to find their own expert, it may be that counsel will be moved to try to find other experts in the future. And it's nice for the attorney who has their own access to expertise without having to answer to anyone else, to be able to go and try again until they find the right doctor with the right formulation for the right case.
Now, if someone has a prior diagnosis, it is not unlikely that that person could say, well, can't you go to my treating doctor and get an evaluation? What is the proper response?
The proper response in almost every case would be that this is very useful information and that you have a release that you would like the client to sign so you can get that information. but that the forensic evaluation is fundamentally different than the evaluations and other services that someone might have received from a treating doctor in the past.
And would there be such a thing as a conflict of interest between the roles of a treating doctor versus a forensic mental health expert?
Yes, there would, and there would be going both ways. The clinician who subsequently conducts the forensic evaluation may wind up being compromised, and the treatment may wind up being compromised. And it is sometimes the case that the forensic evaluator is drafted to provide treatment. That raises concerns as well.
You and I have been using the broad terms doctor and mental health expert. Are the fields of psychology and psychiatry interchangeable? That is to say, is a criminal defense lawyer who is looking for a mental health expert, um, does it make a difference what both specialties do?
It can, in cases where the issue is the function of a certain kind of medication, then the psychologist is most likely to send defense counsel along to a physician or a pharmacologist. I'll often get requests from attorneys along the lines of, my client is taking this medication. How might it have affected them in the past? What different sort of medication might my client need in order to become competent to stand trial? Psychologists might know, but they are certainly not the most likely suspects as experts to make this explanation. If there is an evaluation that's going to turn substantially on psychological testing, then as the name suggests, counsel's more likely to be looking for a psychologist. Those are a couple of examples.
You talked about testing very briefly. Typically, when a competency examination is being conducted, what sort of tests are administered?
That would depend upon the needs of the case. It would depend also to a considerable extent on the client's abilities. There are, for example, highly evolved, complex personality tests that have their fans and detractors amongst criminal defense attorneys anyway, that certain persons with minimal reading skills and low intellectual functioning manifested in other ways are incapable of taking validly and reliably.
If a criminal defense lawyer wants to sit in on an evaluation, and in particular during the testing component, is this something that you typically welcome?
There are concerns in a few areas. Some of them are more counsel's concerned than the doctor's. For example, this may not be a precedent that counsel wants to set locally or regionally or nationally for other persons being along for the ride. For example, prosecutors. It's just a step from defense counsel's presence at the evaluation away to a requirement on the part of the court that the entire evaluation be video and audio recorded. And the defense attorneys will not find it difficult to see why they might not be in favor of that. From the mental health professional's point of view, there are concerns about test security, and beyond that, the ongoing usefulness of the tests if third parties are allowed to be there in person.
And if after the interview, or interviews, if after the testing, a written report is produced, who then decides if in fact the client is competent or is the evaluation in itself enough?
The evaluation sometimes winds up being enough if it is generated in a case where the judge has considerable confidence in the doctor, or when the parties, as is often the case, are simply looking for someone to state the obvious so that everyone can move on. But as a technical and typically practical matter, the psychologist can render an opinion. The psychiatrist can render an opinion, but it is the judge who renders a decision and decides formally who is and is not competent to stand trial.
So let's say after a full hearing on the issue of competency, or perhaps after merely reading the report, the court decides that an individual is in fact not competent to proceed. What happens then?
That depends on the jurisdiction. What is likely to happen is that there is a determination made directly afterwards as to whether or not the person may be restored to competency. Restored is the industry term, and it can be a bit misleading in some cases because it suggests that someone was competent previously and could become competent again. But the court would have to decide whether it's worth the time and the effort, whether there is a substantial enough likelihood that someone could attain competency, that they would put that defendant through the training necessary to see and the treatment necessary to see if they can become aware of the nature and consequences of the proceedings and become capable of participating rationally in their own defense. There's also the issue of whether, after a finding of incompetency, perhaps a finding that competency is never going to be restored, that the person would be subjected to an involuntary civil commitment.
And my sense is that for many conditions like an intellectual or developmental disability, or perhaps dementia, competency can either never be achieved or it can never be regained. In that case, the whole exercise of restoration seems rather absurd and futile.
That would certainly be defense counsel's argument in many cases. That let's stop this now. Let's move on to issues of habilitation instead of cure. Let's find a place for this person to be that is not a jail or prison. Prosecutors may, as indeed one did in a hearing in which I participated this morning, may be focused more on the protection of the community in particular, and the idea that, competent or not, this person needs to be placed somewhere where they cannot get into any trouble. There's a lot of argument that can continue to occur after a determination of incompetency.
And then on the other hand, I want to discuss individuals with mental illness. Let's say they go to an institution and they receive the proper medication in the proper dosage, and they are restored, and then they're sent back to county jail where they are not given the same sort of medication in the appropriate dosages, and they quickly decompensate. How can we stop that revolving door?
Counsel will often have a critical role to play there by continuing to monitor their client's status, by alerting the court and alerting the experts to any concerns that arise about a deteriorating condition. because it is comfortably prior to trial rather than at trial that such concerns are best addressed.
Now, I'm going to ask you a rather delicate question, but are there instances where you, as the forensic psychologist, do not write a report?
Yes, there are. And there are a number of different ways that this occurs. For one thing, and most basically, defense counsel doesn't request a report. And that may be, frankly, because defense counsel does not want the rest of the world to hear my conclusions in a particular case. In some instances, counsel has that opportunity. It may be that it was never contemplated that a written report would be necessary even by the court. That, of course, is certainly not what happens in every jurisdiction, but it's another possibility.
If after the interviews, if after the testing, it is determined that an individual is in fact competent to proceed, can counsel put to good use the work that you have done?
They often can. If there was enough of a concern that competency needed to be addressed, then this work may wind up being the entree to a number of different medically and or psychologically informed issues. For example, criminal responsibility or the insanity defense. Another example would be mitigation. Another example would be extreme emotional disturbance or heat of passion in jurisdictions that allow for diminished capacity issues to be aired. And there may be questions about Miranda waivers and a closely related notion of false confessions. There are a lot of different ways in which the work winds up being repurposed, including in those situations where someone who was previously and accurately determined to be competent to stand trial suddenly is no longer competent, as you've indicated earlier. And I would add to that, for certain jurisdictions, competency to be executed.
As perverse as that might sound. And a practical question. A few moments ago, you mentioned the term criminal responsibility. Can the mental health expert who is evaluating for competency to proceed also conduct an examination for criminal responsibility, sometimes called insanity?
They can, but they are best advised to make sure that that's what they are being asked to do. And it also may be that for good reason, opinions on those two issues would not be expressed in the same report.
Final question for you, Dr. Drogin. You have maintained an active forensic practice for many years, and you have worked with probably hundreds, if not thousands, of attorneys by now. What is the one practice point you would give attorneys, in particular, newer attorneys having their first case in this area?
Seek consultation from experienced peers. It's what I'm trying to convey, for example, to my law students all the time. You, counselor, are in charge of this case. The early career attorney who enables the doctor to, in effect, tell them what to do is not doing the client any favors. If there's a concern about what to do, go ahead and get the doctor's input if that might be helpful. but it is always going to be one's learned peers and or one's boss that will actually be providing the legal direction in a case, even if it turns out that the expert in question is also an attorney. They're not your client's attorney, you are.
And that will be the last word. Dr. Drogin, thank you so much for the valuable information you have provided us. And again, thank you for the wonderful chapter you produced.